If this is your first time hearing about it, one powerful Supreme Court decision may have just cracked the foundation of nearly every gun regulation in the country. The aftermath? A legal avalanche that's been knocking down firearm restrictions left and right. So what's behind this seismic shift? In this video, we're going to break down how a single sentence penned by Justice Clarence Thomas has redrawn the battlefield for Second Amendment rights, and why some folks believe it spells the end for modern gun control as we know it. Whether you're a dyed-in-the-wool Second Amendment supporter or just curious about the legal shockwaves this ruling has sent across the nation, stick with me. What we're talking about isn't just another headline, it's potentially the most groundbreaking development in gun rights history. Roll back the clock to the year 22. That's when the Supreme Court took up New York State Rifle and Pistol Association versus Bruen. At the heart of the case was New York's rule that citizens had to prove a special reason to carry a concealed handgun in public. And no, simply wanting to defend yourself wasn't enough. The New York State Rifle and Pistol Association took issue with that, arguing the rule put unconstitutional obstacles in the path of everyday Americans exercising their rights. Once the case reached the nation's highest court, everyone knew it would be big, but nobody expected the ruling to be this far-reaching. The Supreme Court didn't just overturn New York's law. It completely changed the playbook for how firearm laws will be judged going forward. Until then, courts had used a so-called balancing test, weighing public safety concerns against individual rights. That meant courts often leaned on things like crime statistics, police recommendations, or even speculation about the dangers of certain firearms. Second Amendment advocates, myself included, have long argued that this approach diluted the plain text of the Constitution. You can't balance away a right that's clearly written into the Bill of Rights. And Justice Thomas? He agreed, and then some. He laid down a bold standard. If the text of the Second Amendment covers a particular action, like carrying a handgun for self-defense, then it is protected, period. Unless the government can show that a similar law existed when the Second Amendment was ratified back in 1791. That's the game changer, what we now call the historical tradition test. From now on, modern gun laws must have a historical twin from the era of the Founding Fathers. No historical precedent, no justification for the law. And here's where it gets exciting for folks like us. Back in the late 18th century, there were no magazine limits, no bans on specific types of firearms, no licensing hoops for the average law-abiding citizen, and certainly no requirement to explain why you needed to carry. Ownership was common, expected, and unrestricted in ways today's lawmakers can't even imagine. So when modern laws don't line up with that tradition, under the Bruen ruling, those laws fall apart. Since that decision dropped, we've seen a domino effect in the courts. Judges at both the state and federal levels have leaned heavily on Justice Thomas's sentence to knock down concealed carry restrictions, bans on so-called assault-style weapons, magazine capacity limits, and even regulations targeting homemade firearms. Some courts that once upheld these laws are now signaling that, under the Bruen standard, these restrictions probably won't hold up in future legal challenges. In fact, we're watching entire sections of modern gun control law get swept off the map, all thanks to one sentence grounded in the original meaning of the Second Amendment. So how did just a single sentence become the legal wrecking ball behind so many rulings? It comes down to a powerful premise. The Second Amendment isn't some kind of second-tier right. The Supreme Court made it clear. judges are not allowed to treat it like a privilege that's constantly weighed against modern safety theories. Instead, it deserves the same level of protection as core freedoms, like the right to speak your mind or to worship as you choose. The real shift here is in the burden of proof. After Bruen, it's no longer up to gun owners to convince the court that a regulation is unconstitutional. Now, the government has to do the heavy lifting, showing that any firearm restriction has a direct link to practices in place at the time the Second Amendment was ratified, back in 1791. If there's no historical precedent from that era, the law doesn't stand. Right after Bruen hit the books, New York jumped into damage control mode, trying to push through a revised set of regulations to hold on to some form of carry control. But those new rules quickly got dragged into court as well. The reasoning is simple. If their new permit requirements still demand subjective approvals or modern-day justifications that never existed in the 18th century, they flunk the historical test, plain and simple. And it wasn't just New York feeling the pressure. Hawaii, which had some of the most locked-down concealed carry laws in the country, saw its own rules slapped down by a federal judge who found major sections unconstitutional. California, long known as ground zero for aggressive gun control, is now neck-deep in lawsuits. Limits on magazine capacity, so-called assault-style weapons, and even background checks for ammunition purchases are all being torn apart under the same legal microscope. For folks who still believe in strict gun control, this all might sound like a disaster. But from where I sit, and I've been in the firearms world a long time, it looks like a long overdue course correction in American law. The right to bear arms has, for decades, been tangled up in red tape, treated like something to be licensed, delayed, or denied altogether. But we don't put those same chains on the First Amendment. We don't ask for a permit to speak freely or to attend church. Now, in the wake of Bruen, the whole framework is getting rewritten. Courts are reassessing everything, from how states designate so-called sensitive places, where firearms are banned, to the way they define specific categories of semi-automatic rifles. The founders didn't outlaw commonly owned weapons. They didn't place limits on how many rounds you could load. They certainly didn't demand that everyday citizens justify why they wanted to be armed. That kind of logic just didn't exist in 1791. Sure, critics argue that things are different today, that firearms are more advanced, society is more complex, and risks are greater. But the court's response is crystal clear. Unless a law can be traced to an actual rule or regulation from the founding generation, it probably doesn't belong in a modern legal system grounded in the Constitution. And here's where it gets even more interesting. This new historical test doesn't only apply to guns. The Second Amendment doesn't limit itself to firearms. It uses the word arms, which historically covered a wide range of personal weapons, from swords and sabers to daggers, tomahawks, and early firearms. That opens the door to legal challenges against restrictions on knives, tasers, or even non-lethal defensive tools. Take blade laws, for example. A lot of states and cities restrict the length of knives you can carry, but unless someone can dig up a similar regulation from 1791, those modern rules are now on shaky ground. The ripple effect here isn't minor, it's massive, and we're only just starting to see how far it'll go. Another angle that's turning heads is just how rapidly federal judges have begun quoting that pivotal sentence from Justice Clarence Thomas. If you take a look at recent court opinions dealing with gun laws, you'll notice that line popping up over and over. The logic is straightforward. Once it's shown that a regulation impacts conduct clearly protected by the plain wording of the Second Amendment, like carrying a sidearm, the burden shifts to the government. Officials must then demonstrate that their rule has a direct connection to historical practices from the time our Constitution was ratified. In an overwhelming number of cases, though, the historical trail goes cold. The record is either completely silent or too vague to support modern restrictions. That leaves courts with little choice but to strike the laws down as unconstitutional. What we're witnessing now is a tidal wave of court victories for the Second Amendment. The trend is so strong that some lawmakers are trying to rework their firearm restrictions in hopes of slipping them past this new historical test. But most of those efforts are falling flat. A major obstacle they're running into is the difficulty of interpreting what actually qualifies as a valid historical comparison. Gun control advocates will sometimes dig up obscure ordinances from the 18th or 19th centuries that disarmed individuals considered dangerous or untrustworthy. But those rules were extremely specific, targeting threats to the public during times of unrest or rebellion, and weren't broad, sweeping bans. Courts are now asking a critical question. Is a modern law genuinely equivalent to one from the Founders' era, or is it just overreach hiding behind selective history? More often than not, today's gun control statutes are far broader than anything lawmakers in 1791 would have considered acceptable. Take a step back, and the bigger picture becomes clear. We are seeing a full-scale shift in how the Second Amendment is treated, not as a privilege to be rationed, but as a foundational right the government must respect. The debate is no longer just, should civilians be allowed to own firearms? It's now, does the government have any historical justification to restrict you at all? And if that answer is no, if they cannot point to an example from the founding era, then the restriction doesn't survive. That flips the entire script. For decades, states enforced bans without needing to justify them beyond vague safety concerns. Now, they have to dig into the archives and prove the Founding Fathers would have approved. That's a tough case to make. Let's zero in on some of the regulations currently hanging by a thread. Bans on so-called assault-style weapons, often defined by cosmetic features like pistol grips or adjustable stocks, are looking especially weak under this standard. The Founders never outlawed weapons based on how they looked. In fact, there was no functional equivalent to today's scary-looking rifle laws in the 18th century. Restrictions on magazine capacity are also in serious danger, since no historical limits existed on how many rounds a firearm could carry. Some argue that firearms have advanced significantly since the late 1700s, and that's true. But the technology argument doesn't hold water when we look at other constitutional rights, just like the First Amendment protects your right to free speech on the internet, something the Founders could never have imagined. The Second Amendment still protects your right to bear modern arms. Innovation doesn't erase liberty, and the court is making that point loud and clear. Another major point of contention is the rising scrutiny over so-called red flag laws, rules that allow government authorities to seize firearms from someone based solely on claims that they might pose a danger. Supporters argue these laws can prevent tragedies, but historically speaking, forcibly disarming individuals who haven't been charged or convicted of a crime has no clear parallel in the late 18th century. The Founding Fathers never endorsed preventive disarmament based on accusations alone. And under the Bruen test, that historical gap might prove fatal. If there's no tradition of that kind of preemptive confiscation from 1791 or earlier, courts will likely find these laws indefensible. The conversation around carrying firearms outside the home has also changed dramatically since Bruen. Before the ruling, many state and local governments argued that the Second Amendment only protected keeping a firearm in your residence. But the Supreme Court made it clear the right to bear arms does not stop at your front door. The founders recognized a right to go about armed in public, and that right applies whether you carry openly or concealed, as long as you're a law-abiding citizen. States that used to require applicants to demonstrate a good cause or a justifiable need to get a carry permit have seen those systems unravel under this new interpretation. Now, that same historical lens is being applied to restrictions around so-called sensitive places. Gun control advocates often point to courthouses or legislative chambers as examples of locations where firearms were historically restricted. But today, some states are attempting to stretch that idea to include large areas, everything from public parks and transit systems to entire blocks of commercial space. The issue is that unless they can show that similar limitations were accepted by the founding generation, those designations probably won't stand up in court. Simply slapping a sensitive label on a zone doesn't make it constitutional. This shift is even influencing how we look at ammunition laws. Across the country, jurisdictions have imposed background checks, purchase limits, and tracking requirements for buying ammunition. But let's be clear, in 1791, no one was showing identification to buy black powder and lead balls. There were no registries or red tape. That historical absence is important. And with Bruen in play, you can expect these modern ammunition controls to face serious legal pushback. If there's no analogous law from the founding era, then under this framework, the modern regulation likely has to go. Right now, it feels like we're witnessing a full recalibration of American firearms law. Each new ruling that references Justice Clarence Thomas's key sentence adds to a growing body of decisions that favor constitutional carry and strike down arbitrary restrictions. Unsurprisingly, the shift is stirring controversy. Gun control supporters warn of a return to chaos, a so-called Wild West. But from my perspective, and that of many who believe the words "shall not be infringed" mean exactly what they say, this isn't chaos. It's a long overdue correction. So what's your take on all of this? Let us know in the comments section. Don't forget to like, share, subscribe, and tap that bell icon so you never miss a video. Thanks for tuning in.